Hi, hello. Good morning. Am I audible? Hello.
Yes.
What time we are starting? Hello. Can anyone just confirm what time we are starting?
Hi, ma'am. Good morning. I'm so sorry. I was having a technical difficulty. Can you hear me now?
Yeah, perfectly fine.
I'm so sorry, ma'am. Very good morning, ma'am, and very good morning, sir. Welcome to this oral rounds of the second National PIL Drafting Competition. Ma'am and sir, with your prior approval, should we start now?
Yeah, sure.
Yeah, sure, we can start.
Okay. Thank you, sir. Thank you, ma'am. So I'll request TC2 to start their pleadings.
Am I audible to the bench?
You're audible to me.
Honorable greetings to the bench. The council seeks permission to approach the dais.
Counsel, you're not visible. Please turn on your camera.
Honorable greetings to the bench. The council seeks permission to approach the dais.
Yes, proceed.
Much obliged. May it please the court, with your kind consent, may we collectively address the bench as your lordships?
Sure.
Much obliged. The council 1 would take 8 minutes for the submissions and 7 minutes are reserved for my co-counsel. The Council is deeply honored at the opportunity to present this public interest litigation in the matter for Society for Constitutional Law Discussion Bihar versus the Union of India and others. The Council would now like to seek permission to brief the bench about the facts of the case.
Permission granted. Please go ahead.
Much obliged. Your Lordships, this public interest litigation has been filed to address the growing and concerning trends of censorship and restriction on artistic expression in India. The petitioners have no personal interest, and this has been filed with genuine intention to protect the fundamental rights of the citizens, and an affidavit regarding the same has also been attached, which can be seen on page number 21 and 22 of the memorial. The petitioners represent a class of people who are affected by the respondents' actions. Your Lordships, a BBC documentary, namely India the Modi Question, was released on January 17, 2023, which was blocked by the government, citing no reason or justification under the emergency powers of the IT Act. Then, Your Lordships, a short film, Anthem for Kashmir, was released on May 12, 2022, which was geo-blocked by YouTube due to a confidential government complaint citing no reasons or justifications. I would like to bring to the attention of this Honorable Court that 69A of the IT Act has been used for such restrictions 220 times from 2018 to 2022. There are instances of stand-up comic bans. For example, Kunal Kamra was banned from flying and faced cancellations of his stand-up shows and restriction on his content after confronting a news anchor on a flight. Munawar Farooqi, another stand-up comedian, was arrested mid-performance for allegedly making offensive jokes, and he was charged under sections of the Indian Penal Code and spent 37 days in jail before being granted bail. Your Lordship, these incidents demonstrate a pattern of increasing restrictions on artistic expression in India, raising concerns about the protection of the fundamental rights, especially freedom of speech and expression as guaranteed under Article 19(1) of the Constitution of India. Your Lordship, in the very preamble of the Constitution, it is mentioned that freedom of speech and expression are indispensable part for the development of a person and a free and democratic society. There are three pertinent issues raised in this petition. First, whether the instances of banning are violative of one's rights. Second, which is an extension of the first issue, that whether the provisions for banning withstand constitutional scrutiny. And third, whether the development of comprehensive guidelines will ensure reasonable restrictions on artistic expression. Your Lordships, I would like to, in the light of the issues raised, I would like to plead before this Honorable Court that this public interest litigation has been filed under Article 32 of the Constitution, which grants every individual the right to move to the Supreme Court for the enforcement of their fundamental rights, and also grants the Supreme Court the power to issue directions, orders, or writs for the enforcement of fundamental rights. There are a few judgments of the Supreme Court whose obiter dicta align with the pertinent issue at hand and help in proving the jurisdiction of the public interest litigation. The first one being Vishakha and others versus the state of Rajasthan. Here, the Supreme Court recognized the breach of fundamental rights and issued guidelines, and also a complaint committee and preventive measures were taken place. Your Lordship, which substantiates that breach of freedom of expression should be recognized, and constituting an expert committee to oversee and review artistic ban and censorship is of utmost importance, as the existing guidelines are vague and open to subjective interpretation, which leads to arbitrary decision making and inconsistent application in the decisions. It also leads to over censorship and abuse of power granted to the union government. For example, Article 19(2) talks about reasonable restriction, obscene, public security, national security, public order, but these terms are nowhere defined. This leads to over censorship. Your Lordships, this petition is not a judicial overreach, as for example, in Anthem of Kashmir, which talks about violence and depicts human rights issue in Kashmir, which is a very sensitive and contentious topic, and government actions in this regard have been criticized both internationally and domestically. The government is effectively preventing the public from accessing this information and viewpoints that may be critical of its actions in Kashmir. There are other similar issues as well. For example, Dhruv Rathi's videos, which were regarding the government handling of CAA and COVID-19, and also the Wire, the public platform, many videos of it were removed. All this indicates that the wide scope of the issues and the larger public interest involved in this public interest litigation. Your Lordship, in Sheila Parse versus State of Maharashtra, the issue was that the fundamental rights of the women in the jails of Maharashtra were being violated. The Supreme Court recognized it and directed that the state must provide adequate facilities, including sanitation, healthcare, etc. And in 2016, Ministry of Home Affairs also released a modern prisons manual. The issues at stake in this public interest litigation is also a breach of the fundamental right, and therefore this honorable court has the very jurisdiction to educate upon these matters. Your Lordship, I would also like to plead that while it is true that some stand-up comedians may have made offensive jokes, but it is essential to understand the context and intent behind these jokes. Your Lordship, comedy is a form of expression that often involves satire, irony, and it comments on the societal norms and conventions. It is crucial to understand the context and not what it is being said, but also in how it is being consumed by the audience. While some joke may be thought-provoking for one, they may be hurtful for the another. So therefore, rather than relying on over-censorship, it is essential to adopt a more neutral and contextual approach to regulation. Clear content of not just how it is produced, but how it is consumed, as already stated by me. The Council would now like to proceed towards the locus standi of this public interest litigation. Your Lordship, there have been 134 instances of free speech violation in the first 4 months of 2024 itself, which includes 36 cases of arrest, 36 cases of censorship, and 24 cases of internet control. There are also numerous cases of attacks and lawfare. This demonstrates that the issue of free speech is not limited to just the 3 cases cited, but it is a larger problem that affects a significant segment of the population. Supreme Court has historically recognized a liberal interpretation of locus standi, especially in public interest litigations in landmark cases such as Vishaka versus the state of Rajasthan. By filing a collective petition, the petitioners are able to highlight the larger pattern of free speech violation in India and demonstrate the need for a more comprehensive solution. For example, censorship of a BBC documentary affected not just the filmmakers, but also millions of individuals who were denied access to it. Geo-blocks of Anthem for Kashmir has affected not just the filmmakers, but also all the Kashmiris who were denied the opportunity to express themselves through art. Writing a letter to the Central Board of Film Certification or any of the banning authorities would be futile, as it would not address the underlying issues of censorship and free speech it violates. The pressing issue not just affects individual rights, but larger public interest. Supreme Court has a constitutional mandate to protect and enforce fundamental rights such as freedom of expression. The petitioner's decision to approach the Supreme Court is consistent with its mandate and the Constitution's role as a guardian of the Constitution. Your Lordship, the Council now seeks permission to call upon my co-counsel to delve deeper into these issues and give her submissions. Much obliged.
The Council will be presenting a combined version of Issue 1 and Issue 2, which are that the instance of banning violates people's rights and the provision for prohibition are in fact fails to withstand the constitutional scrutiny. The third matter, however, would be dealt separately. The Council would like to emphasize that the act of banning by the state and the non-state actors are violative of one's fundamental right as mentioned under Article 19, Clause 1, Subclause A of the Indian Constitution, which talks about freedom of speech and expression. The Supreme Court highlighted the importance of freedom of speech and expression in any democracy in the Ministry of State, Ministry of Information and Broadcasting versus Cricket Association of Bengal. However, the current censorship practice, particularly targeting digital content, creates a chilling effect on democracy that not only discourages artists from expressing themselves, but also infringes upon one's right to receive and share information, which is extremely violative of a democratic country. The acts of banning done without providing a clear justification simply to silence the criticism against government makes it a traumatic experience for any artist, which fails them to allow to freely express themselves and their creative ways. The Indian censorship of artistic expression violates its international obligation under Article 19 of ICCPR and UDHR with recent actions of lacking transparency and justification. These violations are also highlighted in a Global Expression Report by Article 19 that states that India's freedom of expression is in state of crisis as mentioned in annexure number 5 on page number 27. I hope the bench is with us on the same thing. This level of crisis can also be understood by the fact that there has been close to 9,849 blocking orders in 2020 alone by the government with the usage of Section 69A of the IT Act 2000, which allows the government for the blocking of the online content at their own discretion. The vague term used in this section, like sovereignty and integrity of India, security of India, and public order, etc., raise concern about the process and transparency, enabling arbitrary restriction on free speech and expression, which is extremely hard for any artist. Moving on, the current censorship practice in India often rely on subjective moral interpretation and fail to meet the standards set by Supreme Court in Shreya Singhal versus Union of India, which includes that the government cannot issue blanket bans without due process and a clear justification. The UN report of the Special Rapporteur on the Cultural Right highlights that the censorship harms artistic expression, resulting in not only cultural and economic losses, but also stifles important societal debates. Moving on to the third issue, the Council believes that the development of comprehensive guidelines will ensure a reasonable restriction on artistic freedom. It is essential that the restriction should be narrowly defined. Even the Shreya Bengal Committee recommendation for film certification submitted in 2016 advocated for more transparent and efficient process. The recommendation for the same can be seen in para 22 on page number 19. I hope the judges are able to locate the same. Your Lordship.
Yes, I am.
Okay, thank you so much for your reply. Now, moving on, the systematic nature of artistic censorship in India necessitates foreign judicial intervention, which is essential to not only safeguard individuals' rights, but also to enhance democratic discourse. Issuance of guidelines by court, as done previously in numerous cases, as also mentioned by my co-counsel, including Sheila Barse versus State of Maharashtra, would ensure that such artistic freedom is preserved in India and maintained. Now, the Council would like to seek permission from this honorable bench to move on to the prayers and the pleadings.
Permission granted.
Much obliged. The Council would like to plead, first of all, to direct respondents to create transparent guidelines for regulating artistic content. Second, to declare arbitrary ban on artistic content without due process as unconstitutional. Third, to prevent arbitrary cancellation of artistic performance and to protect artists from any sort of undue harassment. Fourth, to constitute an expert committee to oversee and review the artistic content bans and censorship, or at the discretion of this court, pass any order, direction, relief that this honorable court may deem fit in the interest of justice, equity, and good conscience. Thank you so much. It was a pleasure pleading before such an honorable bench.
Thank you, Your Lordship.
Counsel, I have one question. Are you also seeking any interim relief?
We would like to seek an interim relief of writ of mandamus. It hasn't been mentioned in our prayer as of right now, because it will be further incorporated in the revised version, which we will share through court master after this session. It was a mistake on our part, but our main relief is to sort guidelines that discuss this whole ambit of issue rather than simply these three instances.
I have another question to both of you. So you mentioned violation of fundamental rights. So, I mean, just to seek more clarification, what are the forums you can approach for the violation of your fundamental rights? Any one of you can answer.
The council one can answer the question.
Your Lordship, for the breach of fundamental here, the petitioners had the option of going to the Central Board of Film Certification by writing a letter or a notification to any of the banning authorities. Also, the Central Policy Guidelines also provide mechanisms for the redressal of such grievances. But at the same time, these mechanisms are not transparent and accountable. They are subjective to the interpretation of the authority itself. Therefore, this leads to over-censorship and abuse of power. Therefore, we require a more nuanced and comprehensive guideline mechanism for such issues where if there is a breach of fundamental rights, particularly freedom of speech and expression, then the petitioners can approach the relevant authorities. Also, the union government has the power to legislate on these issues through union list or the list number 1, entry 31 and 32, which talk about telecommunications and information and broadcasting.
So, okay, let's examine this. Are you trying to tell me that you don't have faith in other forums and hence you are before the Supreme Court, or am I reading it wrong?
No, the council too would like to answer the same. That is not at all our intention. The biggest problem with the grievance redressal, as mentioned in IT Rules 2021, I believe, the grievance redressal mechanism is mentioned, but it's not specified for which violation we should go for specific forum. That's the biggest problem. Although there is some sort of grievance redressal mechanism existing, but there is a problem because it is not clear. The government has failed to clarify it again and again. And as the instances stated, even the anthem of the Kashmir, the government did not give any sort of justification. Even if we go to these forums, the justification is not given because it is subject to interpretation. The restrictions mentioned in these forums are extremely broad in their scope, and for the same we require Supreme Court to create a nuanced and specific guidelines. That is the main concern.
Also, Your Lordship, I'd like to add that most of the censorship that occurs is primarily focused on expressions that are not in favor of the government or the ruling authorities, as is evident through the cases that me and my co-counsel stated before.
Okay, thank you. I'm satisfied. I mean, the other judges can ask the questions.
Much obliged, Your Lordship.
Thank you so much.
Council, to what extent do you think that this does not falls within the ambit of 19 clause 2?
This, to a very huge extent, this does not fall under the ambit of Article 19, Clause 1, Subclause A, as there has been a clear violation of people's fundamental right of freedom of speech and expression, as again and again, as the instances state, again and again, artists have been denied from performing and expressing themselves, and along with that, also denied from receiving and sharing information, which is also part of the fundamental right of the Article 19, Clause 1, Subclause A.
Right, Council, but that is particularly and categorically why I've asked you that what is the specific violation as specific aspect of 19 clause 2 which according to you is not being followed or the purview of the ambit is not being followed. 19 clause 2 I'm asking particularly.
A very important aspect of Article 19, Clause A, Clause 1, Subclause A is that
No. The council, the question is with respect to the question is with respect to the reasonable restrictions, because if in the purview of the bench, it seems so that to some extent it can be considered broadly as a part of 19.2. So which particular aspect, according to you, it is not within the ambit?
Yes, one of the biggest important aspect is the restrictions should be proportionate and reasonable. The restrictions that are like banning is not at all proportionate in nature. What if government felt like that banning was important because of some part of it were not something that could be shared in the public, they could have just specifically removed that part. But the when we're talking about the ambit, when the stand-up comedies have been cancelled, where the stand-up comics are not allowed to perform, then the ambit increases a lot. I hope that answers the
But
question.
council, what if it actually causes a law and order issue then in that case?
Your Lordship, I'd like to answer that question. On streaming platforms, there is the option of reporting mechanisms and also age-wise categorization of various content is available. So if
that is for the online aspects, but the council has been time and again referring to the permissions not being granted to the stand-up comedians to perform physically, right? So, in that context, the online mechanism aspect, the filtration which you are referring to, that won't apply.
But the council too would like to answer that. But always there existed age restriction for that. And when referring especially to Munawar Farooqi instance, what happened was the comic was not even allowed to say allowed his joke, and there was a politician's son who arbitrarily cancelled the show, which shows the overreach of the government once again, and is a broader issue that needs to be addressed.
The politician's son cancelled it, whether it was a show organized by the government.
It wasn't a show organized by the government, but the politician's son filed a case against the Munawar Farooqi. As in, I apologize for the misinterpretation of the facts. He was the one who filed the case against Munawar Farooqi and FIR for the same. And it was done without even listening to the jokes. So that is obviously a clear violation of the fundamental right.
Yeah, but listening to the jokes for that regard, we don't have a censor board kind of mechanism in India as far as the stand-up comedies are concerned. So, what if the police or the local authorities were under the apprehension that a law and orders issue or a communal issue may arise? So, under taking a preventive step, they have taken this decision.
Yes, Your Lordship, that is particularly what we are seeking through this petition, that we need a more comprehensive and nuanced guidelines so that such censorship, over censorship can be avoided and proper guidelines are put in place.
I would like to step in here exactly why I asked you the first question. If you need like curated guidelines on this particular issue, are we the right forum for you to approach? Because
Exactly.
because we are an appellate court, and here if you're seeking or very because you will find the technical members on those forums. Did you try and approach those forums first and then came
Yes,
to Supreme Court?
Your Lordship, this was particularly the case in Sheila Base versus State of Maharashtra, where Sheila Base, a journalist and social activist, filed a PIL in the Supreme Court, which is the appellate court, for the breach of fundamental rights of the women prisoners in the jails of Maharashtra. Here, the Supreme Court directed the state to issue guidelines and ensure facilities are put in place. And therefore, in consequence, in 2016, Ministry of Home Affairs released a modern prisons manual. Here too, in this PIL, there is a breach of fundamental right, and therefore the Supreme Court is the right forum to grant necessary directions to the authorities and state for development of such a comprehensive guidelines to prevent the overreach.
Council, as far as the prayer is concerned, your prayer number 2 and 3, to some extent, prayer number 4 may also be taken into consideration, maybe. But, Council, how prayer number 1 is constitutionally permissible as far as the Indian constitutional scheme is concerned? Do you think that this court is the right forum? And are we constitutionally allowed to issue directions to the parliament or the government to perform their functions?
But there have been instances of the case, as mentioned, Sheila Barse, and along with that, even there were two more cases. I would ask my counsel. I will ask
Arebe,
counsel one.
are you aware of the Vishaka guidelines?
I am not specifically as such aware of the niche guidelines, but overall issues I know. And Vishaka guidelines has been stated by my co-counsel in her argument also.
Yeah,
That
exactly. The
there was
point
also.
is the Supreme Court gave the judgment somewhere around in the late 90s. But the guidelines were made by the government in 2013 for the very reason that this court is not constitutionally permitted, is not constitutionally allowed to issue any directions to the parliament or the government to do any functions. It is their domain. We have to respect the scheme of separation of power. Don't you think so?
Your Lordship, Article 32 particularly grants the individual to move to the Supreme Court for the enforcement of their fundamental rights, and at the same time grants the Supreme Court the power to issue directions, orders, and writs for the enforcement of these fundamental rights.
Enforcement of fundamental rights through pair number 2, 3, and 4, to some extent, as I am again saying, may be considered, may be accepted. But as far as issue number 1 is concerned, the relief can it be to the extent of issuing directions to the parallel organs, parallel constitutional organs, and they have their own respective domains? Don't you think it would be a clear-cut case of judicial overreach, and then we will be, charged for the same?
But again and again, as the precedent states, there have been very many instances where court has directed the although the direction came later on, but still there has been instances where court has told again and again the legislator to make laws that
Maybe the previous predecessors or the previous judges would have committed the mistake or would not have respected the boundaries of a separation of power. So do you want this court to repeat the mistake again and transgress their constitutional boundaries?
that would be contempt of court. We wouldn't go in that area. I apologize.
Okay. Okay.
Thank you so much.
Much obliged, Your Lordship.
Sir, should we allow the other team to join?
Uh, yeah, no problem from my side. If the co-judge is also fine with it.
Yeah, fine.
Okay, I'm allowing other team to join. TC2, you can leave.
Thank you so much.
You can leave the meeting.
Okay.
Thank you so much.
Okay, thank you so much. Thank you so much for the judges also.
PC02, I think you should leave the courtroom.
Ma'am and sir, with your prior approval, should we start with TC10?
Yes, yes. I think we should start.
Right, sir. TC3, you can start your pleadings.
Thank you. Am
Just
I
one
audible
clarification.
clearly?
We still have TC02 in the meeting, and the team which is starting is TC10.
Where's your co-counsel?
Ma'am, we were allowed to participate individually, so I have
Yeah, I
participated
do that.
individually in the competition.
Okay,
Okay.
I did.
And yeah, okay, then start.
TC2 has left.
Yeah, start.
All right.
Greetings to the panel and the council presents for the argument in the capacity of TC 010. The council seeks permission to address the bench collectively as your lordships.
Please go ahead.
Much obliged. The council has approached the honorable court to seek justice for a community in our society who have been neglected for ever since. They are not just present in our society in human form, but God Himself or herself has given their blessings to them in the form of nourish. We're talking about the queer community who have been neglected, and recently, over a decade has passed when they've started asking for such rights which they should have been given as a human, as a citizen of India. The present case bring forth such an issue where a couple of same sex wish to legalize their marriage and register their marriage under the Indian laws. But to their surprise, they found out that there are no such laws which legalize same sex marriage in India. Aggrieved by this, they started researching and looked for various other same instances. And they came across another couple who were not necessarily looking for legalizing their marriage, but they were very much keen to adopt a child as a couple. But they were also denied such a pious right to have a family and to adopt a child just because they were not recognized as a legally married couple. Therefore, to challenge this, the adoption regulations of 2020 and to seek right to marry as a fundamental right, they have collectively approached the Honorable Court. If the Lordships are versed with the facts, the Council would seek permission to move forward with the issues.
Yes, please
Yes,
go ahead.
ma'am.
Much obliged. The Council will be dealing with three major heads of the issue. The first being maintainability of this public interest litigation, second being right to marry as a fundamental right, and third, the violative stance of these regulations. The first issue states that whether denial of right to recognition of marriage of same-sex couples is a valid ground for filing a public interest litigation under Article 32 of the Constitution. The Council will be establishing the maintainability on the basis of three illustrative grounds. The first is public interest. As PIL's foremost objective is to serve public interest, and in the present case, the public interest of a specific section of the society or a specific community of the society is adversely affected and they have been denied basic rights. In the case of Bandhua Mukti Morcha, Justice P.N. Bhagwati stated that any member of the public acting bona fide for a person or a class of person in violation of fundamental rights can approach this honorable bench in the form of public interest litigation. Secondly, since our fundamental rights have been borrowed from USA's Bills of Rights, we can also look forward to borrow some redressal mechanisms from same legal tradition. One of them is such public interest litigation. In the case of Syria Club versus Morton, the US Supreme Court held a party seeking review must allege facts showing that he himself is adversely affected. And in the present case, all the petitioners are individually and as a community are affected. The very second contention is violation of fundamental rights. Marriage as a fundamental right, though has been denied by the majority opinion in the case of Suprio versus Union of India. But the council would like to focus on the fact again and bring into notice of this honorable court that in the case of Lata Singh versus State of Uttar Pradesh, where a case of intercaste marriage was there, this court has given right to choose a partner, and nowhere in the judgment it was mentioned that it applies only to heterosexual couples. However, we also have signed the UDHR, Universal Declaration of Human Rights, and Article 16 of the UDHR expressly states that right to marry and found a family is a basic human right. Though the council understands that at the time UDHR was being drafted, was being formed, and India was being a signatory to it, it was not in a position to allocate such a right to its citizens since the social and the economic capacity of the country was not in the right position. But today, India is the fifth largest economy across the globe, and the societal and the modernized concepts have been inculcated very deeply now. So, the council feels that this is the appropriate time that right to people who have been neglected ever since should be given. And lastly, to make the maintainability valid, and we need to address the social inequality in the society. Marriage as an institution holds historical value. So does same-sex couple. If we look into historical literatures, and one of the famous and one of the very A uh, very much read literature was Kama Sutra, where women were given right to marry other women. Now, with modernized culture and society, it is very important to end this, to put an end this discrimination on the people with different sexual orientations. The council seeks permission to move forward with the next contention.
Permission granted.
Much obliged. Second issue which the council came across and would like to put forth before this bench is whether the right to marry is a fundamental, as partially discussed in the previous issue. Right to marry should be right to marry is a fundamental right on the basis that if we are not giving right to marry to people of different sexual orientation, it clearly leads to violation of Article 19 as well. As in the case of Shafin Jahan versus Ashok KM, this court clearly observed that choice of a partner, whether within or outside marriage, lies within the exclusive domain of each individual. Intimacies of marriage lies within core zone of privacy, which is inviolable. Therefore, it is interpreted as a part of right to privacy, which is a fundamental right as per the case of K.S. Puttaswamy of 2017. The second ground to validate this is recognition of LGBTQAI plus community. In the case of Navteet Singh Johar, this court has held that queerness or homosexuality is natural. And if we have such a great step towards the societal shift, then giving effect to that, we have given rights to homosexuals as a we have decriminalized section 377 of Indian Penal Code. Since the concept of homosexuality has been decriminalized, sets a great societal shift. But just decriminalization is not sufficient. Giving rights to homosexuals is also important. Globally, same sex marriages have been recognized as equal to heterosexual marriages. And if we look to one of the major cases of US Supreme Court, in the case of Baker versus Vermont, the court held same sex couples can't be excluded from the benefit, whether the benefit, where the benefit can be decided by the state, whether it is conferred within the framework of marriage or as a domestic partnership. But this concept of separate but equal should be abided by, taking into account one of the very recent notifications of the Ministry of Finance, where joint accounts for same sex couples have been permitted. We are moving towards a societal shift, and it is very important to recognize the rights which the same sex couples, the heterosexuals, the queer community should have been granted in the very first place, and they should not be fighting for their rights. And the last issue which the council would like to put forth is whether the adoption regulations of 2022 are violative. The council would like to take 2 minutes to jot down the few issues which have been faced by people in adoption regulation of 2022. First is the Rule 5, Subclause 3. It clearly states that only men and women, only couple who are consisting of men and women can adopt the children, but nowhere it mentions, there is no stats that only parents of heterosexual couples are good enough to take care of a child. We have not given the right to homosexual couples to adopt a child, but we have given them right to adopt individually. How does that not discriminate? This leads to clear violation of Article 14, Article 15, and Article 21 as well. So in the case of Superior versus Union of India, the CJI in a paragraph held that expressing his minority opinion stated that the Union of India has not proved that precluding unmarried couples from adopting is in the best interest of the child. So the authority has exceeded in barring unmarried couples. When the CGI in itself have such a great thought, then why should not we consider legalizing same-sex marriage, or not just legalizing, giving them such basic rights such as adoption, healthcare benefits of each other as a partner? The council would now like to move forward with the prayer. The council seeks permission to move with the prayer.
Please go ahead.
Obliged. Whereof, in the light of facts used, issues raised, arguments advanced, and the authorities cited, it is most humbly and respectfully prayed before this honorable court that the court may be pleased to adjudge and declare right to marry as a fundamental right, and declare Indian adoption rules and regulations violative of Article 14, 15, and 21 of the Indian Constitution, and or pass any order it may deem fit in the interest of justice, equity, and good conscience, all of which is most humbly and respectfully submitted.
My first question to you is, do you believe in the institution of marriage yourself right now?
Your Lordship, I extremely am a firm believer of the institution of marriage.
Okay, and but not in its current form, right? That is what I'm presuming, going by your arguments.
Not in the current form for the queer community, because the current
That's
form
exactly
suggests
because,
that the queer community.
yeah, because in the current setup there is no space for homosexual marriages, correct? So in a
Indeed,
way, it's a radical act for homosexual couples, right? I mean, just
indeed.
it's not adhering to the societal norms at the moment, is what I'm trying to tell you, right? So then, why do you want your relationship to be validated by the same very institution that discriminates you? Why are you here seeking intervention, legal intervention of this very court, when the same institution does not? I mean, you can happily live together if there are two people. I mean, I don't think there are any restrictions for two individuals, two adults, to spend their time together, to live together. What exactly are you seeking from this court in this regard? Because if there is an institution that discriminates against you basis your gender, because I mean, at in its current form, they don't allow two people from the same gender to marry. Why do you think it is important for you to seek validation of the same very institution, and you're also seeking legal interventions? Please go ahead.
Um, I'm obliged to have this question put forth. The basic answer for this question would be that when we enter into a legal institution of marriage, we get certain rights, we get certain equalities. For example, a right to adoption for a heterosexual couple is very much easy by the formation of adoption regulations. But for the same for homosexual couples is quite difficult, maybe at this point not possible at all. Secondly, if we move forward with the policy making and the insurance and the health insurance, basically, the partners of heterosexual marriage are being given very much benefits, but the same is not in regards of the homosexual couples. So it is very important to have some amendments in the current institution of marriage to somehow adjust the homosexual couples as the same heterosexual couples have been adjusted. Earlier, we were not in favor of intercaste marriage, but later, with the societal developments, intercaste marriage was also adjusted in the part of institution of marriage. So, with the societal shift, we should also move forward and dwell into a capacity where we can treat homosexual couples equally as heterosexual couples.
So, are you seeking legal interventions in the traditional forms of marriage laws and rules and acts, statutes, or Special Marriage Act? What is your understanding of the same, and where do you seek intervention from of this court?
The council seeks intervention of this court not under the Special Marriage Act, but in the to form a separate to form a separate act or separate statute which legalizes the marriage of heterosexual couples, just as we have permitted the marriage of intercaste couples.
And how would you place?
Council,
Please go ahead,
exactly. Yes,
Abhinav.
please go ahead, ma'am. Uh, Okay. As a council, then you are at the you are at the wrong forum because you are, asking this court to form a new law or legislation which is not permitted. Are you seeking a judicial legislation in this regard?
The council is seeking guidelines for a legislation which will aid the legislature to form a statute. The council is not seeking for a legislation from the judiciary. The council is seeking for certain guidelines.
Are you
No.
considering it to be an effective remedy?
Uh,
Because if the court, if the government, if the union is opposing this particular very idea, then do you think that merely by issuing a guideline from this court, whether the union would be convinced and they would immediately form a law in this regard?
Not immediately, but the guidelines would be an effective remedy for the people of homosexual couples, of the same sex couples. And similarly, guidelines were have been issued in case of Vishakha versus Union of India. The guidelines were firstly issued by the Honorable Court, and then a legislation was formed by the Union of India. So we are seeking for certain guidelines which will aid the Union of India and which will have certain amendments in the thought process of Union of India to help homosexual couples to strive in the society as a legally married couple.
So do
Circling
you
back,
think that,
Abhinav, please go ahead. I'm sorry.
sorry, and no, please go ahead. I'll add the question at a later
Oh,
stage. Please, no.
taking this forward, circling back to my question, I asked you a very specific question. Where are you seeking our intervention? Is it the Special Marriage Act or like the traditional forms of marriage? And you said you want a separate act, which I think, which is where Abhinav stepped in. And so, how again, you yourself have admitted that you want a separate act for this community. Do you think society is ready, even if we, which is not within our jurisdiction to form a separate third kind of legislation, like he rightly pointed out? Do you think the society is ready? Forget about Union of India for a second. Even if that is done, do you think the society is ready? Because you are here in public interest litigation. Do you think other people don't have a right, or other people, because how do you place bisexuals then? How do you place people who are maybe homosexuals but then they also want to do the saptapati and then go by the traditional methods of marriage? Or so how do you place all that? Don't you think it's too complex for the court to decide, and instead the society has to be ready first and then eventually the legislations would come, like you rightly mentioned, that we need to move ahead. But that can't be done by an appellate court, right? What are your thoughts on that? And of course, over to you, Abhinav. I'm really sorry.
No. Thank you for adding, the aspect, the society's aspect. So, counsel, that is the concern of the court, of the bench, that, we don't simply want to recognize a right without a remedy. So, because in the prayers, you have mentioned that to declare right to marry as a fundamental right and to declare, all the other aspects. But the question remains the same, that you need a law, you need a legislation. See, you gave examples about a decriminalization of homosexuality. That is reading down a provision, that is interpretation, that can be done. But as far as this is concerned, our hands are tied. As you specifically said, we cannot declare it or interpret the Special Marriage Act in this regard, in a broader sense, which means our hands are tied, and merely issuing in guidelines in this regard. In fact, for that matter, even guidelines of Vishaka are also an extension of an already existing fundamental right. So in this case, it seems to be that even if we recognize, it would remain a right without a remedy, and that's a concern. That's a matter of concern.
To answer the very first question of the societal interpretation, if we if we look into the quantum of how much homosexuals have identified themselves through a report of Times of India, almost 2% of the homosexuals have came forward because of the societal issue. But now, after the campaigns, after all the awareness programs which are being spread throughout the country, people are coming out of the closet, and that is where the societal shift can be witnessed. All across the world, 32 countries have legalized same sex marriages. And I believe India, being a diverse country, has such a capacity to inculcate another community as a part of India and not denying them particular rights. India is in clear capacity of that, and the societal pressure will be gradually reduced once they are being recognized as legally wedded couple, and they have been given certain fundamental
Anshul,
rights.
see, the problem is, philosophically, it may sound good. We may take global examples, but as the co-judge rightly pointed out, as far as the Indian society is concerned, we have to take into consideration because law is a reflection ultimately of the society itself. So, be it the aspect of codification of the laws, or the idea or discussion on uniform civil code, all of these face restrictions or restraints because of the societal acceptance by society or not. And as far as this is concerned, there are a lot of other allied issues and subjects such as cruelty, such as divorce, such as adoption. A lot of additional aspects are there already. And the moment you recognize and you allow the marriages, then all the additional aspects, which we may also call the other side of the marriage, uh, will also start to that extent, including domestic violence and other aspects. So there are a lot of such things which remain a challenge as far as India and Indian society is concerned. In that regard, we may not compare Indian society from US or other nations. We cannot do so.
And just a parting thought, I don't think my co-judge or me are negating your arguments at this point with, so some countries allowing that to happen and everything. That is okay. But like, I think we are more on our own limitations as the court. Can we do this? I don't think so. Another thing, I was just reminded of that you mentioned same joint account. What was that argument again? You said something about
The
same.
Ministry of Finance, right, ma'am. The Ministry of Finance allowed same-sex couples to have joint accounts.
So, I just wanted to point out then and there, but I kind of forgot. Are you aware that even before you could actually own a joint account? It was not
Exactly.
something which is very revolutionary. So, try to understand also that these kind of rainbowification of existing things, these are things just sort of adding up to the discussion, and it's being projected that way at the moment, but it may or may not necessarily lead to anywhere, because this was already, if two people wanted to, they could own a joint account even before. So
Exactly.
yeah, so when you this like whole sensational to gay marriages and everything, sometimes you feel that there's so much happening, but it may or may not. So that's exactly why I think society needs to be ready for it first, and we are inherently a family based society. I am not saying, again, I'm not negating your comments or arguments on this, but I genuinely do feel that it has to come from the society, because this is something which is like a social institution, and a lot of Indians do firmly believe in it, whether we like it or not.
Ma'am, I would like to add on a point in regards to the joint accounts. Since the society was not in a position to accept the same sex couples or same sex marriages, that is why it was a revolutionary step to recognize it. Earlier, we were allowed to open joint accounts with with people whom we are associated with, but giving it a specific mention clearly states that we are moving towards, we are shifting towards where we are accepting homosexual marriages.
Which is fine, but we are here. Can we legislate a separate, code or an act? That is where we are stuck. I'm not saying that's right or wrong, but what I'm trying to tell you is it may or may not, percolate down, trickle down to something very substantial for you. That's what I was trying to point out.
Ma'am, the council is currently seeking for some guidelines to help the homosexual couples, at least if the court is not able to recognize their marriage, but give them certain rights, such as in the current instance we talked about adoption rights, where a homosexual couple was denied, clearly denied right to adoption. It is nowhere expressly mentioned that heterosexual parents will be the best parents, or there will not be any discrimination, there will not be any harassment or anything. We should at least give a chance to homosexual couples to become a parent, to form a family.
I mean, before that, I think I would like to hear from my co-judge what is his perspective on that, because then in that case we can seek some clarification from the concerned ministries, and look into that. I mean, but let's just I think we need a discussion with the co-judge and his perspective so we can take it forward.
Sorry, I went out of the network for a while. Ayush, were you asking something?
I guess the council had some. You had a prayer. Can you just repeat it?
Sorry, the voice is breaking.
Is it audible now?
Yeah, it's audible now.
Yeah, please go ahead, council. You can just mention it again.
The council currently is seeking, if not the court is in a position to validate right to marry as a fundamental right, but the council prays that at least certain rights, such as right to adoption, which has been denied to homosexual couples, as it is nowhere expressly mentioned that heterosexual couples are the good parents, or they will not discriminate, or there will be no harassment in such kind of relationship of child and parent. We should at least give a chance to homosexual couples to become parent, to raise a child. It is not expressly, or it is not impliedly also mentioned nowhere in the rules that are being created. So the council would seek certain amendments in such rules so that we can allow homosexual couples to adopt children.
Is this part of
Okay.
the?
Hmm. Yeah, is it the part of the written submission?
uh, Indeed, your lordships.
Can you point me out what page?
The prayer is on page number
Okay,
18 b point, and the written arguments are on page number 16 and 17 for the
the
same.
we can't grant something which is not already before the court. Like, where is the prayer?
Page number 18, point number B, to declare Indian Adoption Rules and Regulations 2022 violative of Article 14, 15, and 21 of the Constitution.
I think we will have to, I mean, if the co-judge agrees, I think we will have to speak to the concerned ministry and seek their answer, reply to that. We can't,
Yeah,
again,
sure.
we are not in a position to grant that, but all we can do is issue notice and maybe seek their directions. Yeah.
Exactly. Right. Agreed.
That would be of great help, your lordships.
Thank you, counsel.
Okay,
Thank you, ma'am.
council.
Thank you, sir. The organizing committee, am I allowed to leave now?
Ma'am, sir, should we allow her to leave?
Yeah, yeah.
Yes, please.
Right. All right, you can leave. Thank you.
Thank you, sir. Thank you, ma'am.
So should we call the next team?
Yeah, I'm fine with it.
Okay. TC14, do you have any other concern? Or should we start? TC14.
Yes, sir. Actually, my co-partner is waiting in the waiting room, so please let her in.
Yes, I have admitted her.
Okay.
All right. Sir, should we allow her to start?
Yeah, if the co-judge agrees.
Yeah, please.
Ma'am.
Yes, yes, please.
All right. TC14, you can start now.
Greetings to your ladyship and lordship. The council seeks permission to begin.
Proceed.
If it may please, the council seeks permission to address your ladyship and lordship collectively as honorable bench.
Please
May
go
it
ahead.
please the may it please the honorable court, the council are appearing before you on behalf of the petitioner EIR Foundation in the matter of EIR Foundation and others versus Union of India and others. It is humbly submitted to the honorable bench that we invoke the jurisdiction of this honorable court under Article 32 of the Constitution, seeking enforcement of fundamental rights, particularly the right to life under Article 21. To familiarize the honorable bench with the facts of the case, the brief of facts is as follows. A lease for a diamond mining project in Buxwaha Forest was granted to SL Mining and Industries Limited, which plans to exploit around 382 hectares of forest land, which entails felling over of 2.15 lakh trees, using of 5.9 million cubic meters of water annually, severely affecting biodiversity and leading to deforestation, water scarcity, and loss of livelihood for 8,000 local residents who depend on the forest. It is further brought to the notice of the honorable bench that there had been irregularities noticed in the clearance. There was a lack of proper environmental impact assessment and public consultation as required by Environment Protection Act 1986 and Forest Rights Act 2006. The honorable bench, there are three main issues involved in the present case. First being whether the writ petition is maintainable. Second, whether the grant of lease for mining is ultra vires Article 21. And third, whether the state has violated any environmental laws or has failed to perform its duty. The council will be dealing with issue 1 and issue 2 and would be speaking for 8 minutes. And my co-counsel would deal with issue 3 and would speak for 7 minutes.
Okay.
Coming
Proceed.
to the first issue, the first issue is whether the whether the writ petition is maintainable or not, which the council would be establishing on 3 grounds of petition being made in public interest, second, petition having a locus standi, and thirdly, violation of fundamental rights under Article 21. It is humbly coming to the first ground, it is humbly submitted to the honorable bench that a PIL can be initiated in the court with the purpose of enforcement of public interest, whether the public at large or a class of community has any pecuniary interest or their fundamental rights are affected. Supreme Court has given a criteria of which the court must be satisfied before admitting the PIL. The criteria being the credentials of the applicant, the nature and correctness of the information giving, and involvement of a real and genuine public interest. In the instant matter, the foundation has worked for environment protection, and the matter is in public interest as it not only affects nearly 8,000 people residing within the Buxwaha forest, but also the wildlife of the forest and the nearby corridors. Coming to the second ground, since the grievances in the PIL is about content and conduct of certain government policies, the NGO, having worked for environment protection, has a locus standi to file the petition as PIL. Since the Supreme Court itself has lowered the locus standi threshold to facilitate the filing of such cases. Furthermore, the Supreme Court has also observed that the victim of infringement of fundamental right need not personally approach the court, for the court can take cognizance suo moto, or a PIL can be filed by public spirited person. Coming to the third ground, Article 32 of the Constitution of India guarantees the right to approach the honorable court in case of violation of any fundamental right. In the instant matter, the proposed mining project in the Buxwaha forest stands in violation of Article 21 as it violates the rights of forest dwellers, the rights being right to livelihood and shelter, right to healthy environment, and right to clean water. The third ground would be further dealt with under issue 2. Coming to issue 2, it is humbly submitted to the honorable bench that the grant of lease to SL Mining and Industries Limited is violative of Article 21 of the Constitution of India, and the council would establish this on the grounds of violation of right to clean and healthy environment, right to access to clean water, and right to livelihood and shelter. Coming to the first ground, the Supreme Court has often interpreted Article 21 to extend beyond the literal meaning of life and liberty, and has encompassed the definition to include right to health, safe living conditions, safe environment, clean and healthy environment, and many more. And every person is entitled to a quality of life consistent with his human personality. Hence, the Supreme Court has brought clean and healthy environment within the meaning of life under Article 21. The Supreme Court, in the leading case of MC Mehta versus Kamal Nath, had held that any disturbance to the basic elements of the environment, namely air, water, soil, which are necessary for life, would be hazardous to life within the meaning of Article 21. In the instant matter, the project threatens to destroy a critical biodiversity hotspot, leading to loss of flora and fauna, disruption of ecological balance. A further detailed analysis of the impact of proposed mining project is explained under point 2.1.4 to 2.1.9 of the memorial. Moving to the second ground, the Supreme Court in Narmada Bachao Andolan versus Union of India has held that water is the basic need for survival of human beings and is part of right to life enshrined under Article 21. Supreme Court has further held that water is a gift of nature. Human hand cannot be permitted to convert this bounty into a curse and oppression. The proposed mining project in Buxwaha forest is estimated to use nearly 5.9 million cubic water annually. in our already drought-prone region of Chhatarpur district of Bundelkhand region, which is historically known for the drought-prone phases. The diamond mining project also involves felling of approximately 2.15 lakh trees, significantly unbalancing the ecological balance and natural water cycle. Furthermore, the use of groundwater stands in violation to the Central Groundwater Authority, since no objection certificate for withdrawal of groundwater has been yet issued. Coming to the third ground, right to livelihood and shelter, as emphasized in Olga Tellis versus Bombay Municipal Corporation, has been considered an essential component of right to life guaranteed under Article 21 of Constitution of India. The forest dwellers have been residing in the Buxwaha forest for years, and they rely heavily on the forest resources for their livelihood. They derive their sustenance, shelter, source of livelihood, social and economic status from the forest. The proposed mining project will involve clearing of approximately 382 hectares of forest, depriving the forest dwellers of their primary means of income and sustenance. It is brought to the attention of the honorable bench that the proposed mining project in Buxwaha forest also stands in violation to the Scheduled Tribes and other traditional forest dwellers Recognition of Forest Rights Act 2006, which enables them to hold and live in the forest land and use the land for habitation or for self-cultivation for livelihood. Many families would be left without adequate housing due to destruction of forest, creating a crisis of homelessness and vulnerability, further exacerbated by loss of community structure and social network. Therefore, it is humbly submitted to the Honorable Court that the mining project stands in violation of Article 21 and is capable of destroying the balance within the Buxwaha forest. Now, the third issue would be dealt with by my co-counselor.
Your Lordship, may I proceed?
Please do.
Yes, proceed.
So the third issue in this matter deals with whether the state has violated environmental laws and failed to perform its duty. As we know that forests are vital important component to sustain the life support system on earth. So it is humbly submitted before the honorable bench that Article 48A of the Constitution of India requires that the state shall endeavor to protect and improve the environment and to safeguard the forest and wildlife of the country. But the state has failed to comply with the environmental regulation. As under Environment Protection Act 1986 through Section 2 of Environment Impact Assessment Notification 2006 mandates a prior environment clearance for certain projects. And assessment is mandatory for 29 categories of development activities, including mining projects, which involves investment of rupees 50 crores and more. In the instant matter, the government has granted environment clearance to the project worth the value of rupees 2,500 crore without any adequate assessment and public hearing. This leads to the lack of transparency and violates the principle of natural justice by violating the principle of audi altrum partem or fair hearing. And the grant of environment clearance becomes questionable. Moreover, the government has allowed for the forest land to be used for non-forest purpose without grant of approval by advisory committee, hence violating Section 2 and Section 3 of the Forest Conservation Act. Also, the mandatory consent of Gram Sabha has not been adequately obtained under Section 3, Clause 2 of the Forest Rights Act. An additional clearance of forest is proposed for the purpose of other than purpose enumerated in Section 3, Clause 2, Subclause A to M. Hence, in the instant matter, government, instead of protecting resources for enjoyment of general public, is permitting their commercial exploitation and violating the principle of public trust doctrine as enumerated in MC Mehta versus Kamal Nath. So in the light of the issues raised, arguments advanced, it is humbly prayed that this honorable court may be pleased to adjudge and declare the writ of petition is maintainable, direct and appropriate writ, order, or directions declaring the environment clearance granted to Bakswaha mining project as illegal and void, and direct the respondent to conduct a fresh and comprehensive assessment of Bakswaha mine project with the full public consultation and in the compliance with Environment Protection Act and Forest Act, or pass any other direction, order, or relief that this court may deem fit in the interest of equity, justice, and good conscience. So, ending up with this, as this matter is of immense public importance, the mining project not only threatens the livelihood of the forest dwellers, but also to the biodiversity of a region, vital to our ecological heritage. I urge the court to protect the rights of the vulnerable and uphold the rule of law. Thank you. Your Lordship, we are done with our arguments.
Council, don't you think that, of course, it can be said that the development projects, they do not have certain aspects and they must be sustainable in nature. That's a rule, that's a principle, that's right. But don't you think that the claims which you have made to completely stop this particular project or proposed or ongoing project, this would bring a lot of, developmental lacking on the part of the nation, state, and other aspects.
To
Well,
answer to your
sorry, I
lordship, yes.
lost my connection for the last, I think, 5 to 7 minutes. Am I audible? Are the submissions over?
Yes,
Ma'am.
ma'am, you're audible.
To answer to your lordship, yes, there would be certain impact on the development of the region, but then that's where the principle of sustainable development comes. Furthermore, in the instant matter, what has come to the notice is that the environment clearance granted has been without any environmental impact assessment or without giving an opportunity to the public of that, to the people of that area to have an opinion. They had not been consulted regarding the
Council,
same project.
whether no EIA was conducted or adequate EIA was not conducted.
No
Sir,
EIA
adequate EIA was not conducted.
What are the specific proof of the same?
Sorry, sir.
What is the specific proof that it was not adequate? The EIA was not adequate.
No public hearings were conducted, which creates question on the transparency of the whole EIA process, since no public hearings were conducted. The principle of natural justice has been violated.
Council, did you check with the local authorities if there were any consultations? Because in certain issues where there are technical issues, like general public may or may not have the required expertise or knowledge about the same, because this is a mining project. I'm sorry, I've lost you guys for like the last five, so I don't know. I mean the final submissions, but from your definitely from your memorial. So I mean, have you checked with the authorities? Are you certain that what are the reasons they are citing for not holding a public consultation? Are you aware about those?
Mm, no, you're already sure.
Okay. How are you again alleging that there were no adequate assessment done? How did you conclude that?
So, ma'am, the 7 stages that needs to be conducted in an environment impact assessment.
Council, I
Out
got
of
that. I got that. I am only asking you, how do you know, because you said no adequate measures were taken. So, how do you conclude that? Because sometimes, especially in cases like these where there are, expert evaluation required, so public consultations, maybe they did away with the public consultation, citing certain reasons for it, and sometimes they consult only like a set of public whom they think have the required knowledge and expertise and technical know-how of that particular industry. So did you check with that is all I'm asking.
Yes, ma'am, we did check. There has been a ongoing case in NGT, National Green Tribunal, and from the facts therein, it is confirmed that no advocate public hearing was held.
Okay, please go ahead. No, I don't know how long you've been in this question answer session. I would like to ask my co-judge if he has any questions because I am a environmental person and I do feel if there have not been adequate measures taken, so I think I would like to issue notice to the concerned authorities and wait for their reply on the same.
Yeah, I have also got a clarification from them with respect to the sustainability aspect. So I am done with my part of questions as well.
Also, when we are talking, so are these tribal communities that you've mentioned? Are these forest dwellers or tribal communities? You're not audible.
They are forest dwellers, but they are protected under Scheduled Tribes and Other Traditional Forest Dwellers Act 2006.
Okay, okay. So I think we're inclined to issue notice on this part because this is a
Yeah,
grave, and these are people who basically do not have the means to
agreed.
approach court. So yeah, we're
Right,
inclined.
right. Correct.
Thank you, councils.
You may leave the room, counsel.
Thank you.
Okay, thank you. Thank you, Lordship.
So, Ayush, what is next? We need to fill the scores and send accordingly.
Yes, sir. Yes, sir.
Okay, I'm so sorry. I'm so sorry. I actually lost most of the last team's submissions.
Yeah,
So I
no issues. No, there that was mainly, of course, the cause was genuine, and I was asking them with respect to the balance which is required between development, and you cannot completely ignore development for the sake of, the environmental causes. Also, this is also a concern. So that was a
in
discussion that
fact,
is going on. So